Hello, boys and girls, and welcome to Multinational Corporations. It's a gorgeous day here in Vermtown. I've got my Israeli Army hat on today because we're doing multinational corporations. And this is going to be a scintillating, didactic, and provocative session coming off of last week's business politics. Moving into multinational corporations, I think, is a great follow-up subject. Going back to our good French philosopher friend Voltaire, before you address me, define your terms. So what be a multinational corporation, might you ask? Simply a company that is headquartered in one country that does business in one or more foreign countries. So clearly, depending on the business, you got a variety of types of business strategies and structures. We've got 5 types of internationalization that are characterized in business as export sales. So clearly, making goods in a domestic country and then exporting them for sale to a foreign country is one form of multinational activity. A second is licensing. A company that licenses its brand or its product to be sold in another country, in that country, by that country. Foreign sales offices like John Deere, for example, or Ford Motor Company have offices in foreign countries that represent them and sell their goods. Certainly foreign direct investment, taking funds and investing them by purchasing companies. And then, of course, you have global production. That is, that your company sets up an actual production facility overseas. So Coca-Cola, for example, would be a good illustration of that. So the United Nations tells us that, would you believe, there are over 82,000 multinational corporations that have almost 1 million foreign affiliates. So when we talk about globalization, you can see from a business perspective, hey, these are a lot of business entities that are certainly in the business of providing goods and services and, of course, making money for their owners. So how do you measure a company to determine whether or not, in fact, it's a multinational? Well, they have this thing called the transnationality index that can be used, which says, look, what is the average of 3 ratios? The first ratio being foreign assets to total assets, foreign sales to total sales, and foreign employment to total employment. So what is the average of those 3, ratios? And if it's, certainly over half of what your domestic number is, well, then that certainly would make you a multinational company. So we would all agree one of the biggest multinational companies is Coca-Cola. Coca-Cola has a secret formula that they have. And so when there is when they set up a production facility overseas, they are keeping secret their Coca-Cola formula. But I really recommend that if you ever visit Atlanta, that you should stop in and see the World of Coca-Cola. It's a museum that they have near the Interstate Freeway. And it's really worth your time, because it not only obviously gives you an insight into their manufacturing process, but on the top floor, they have a tasting room. And you get a chance to taste every product that Coca-Cola makes. And you would be astounded to learn how many products they make that they sell overseas, that they make and sell overseas, but that they don't sell in the United States. So one of the most interesting products that I tasted, and you can taste as long as you want all of their products there at the end of the tour, is, of all things, it's called tree bark. Yes, they have a drink called tree bark, and it's only sold in Southeast Asia. And when I tasted it, obviously curious as to how this foreign product tasted, wow, it tasted like tree bark. I'm here to tell you, it would never sell in the United States, but it's popular in Southeast Asia. So, how does Coca-Cola do business as a multinational? Well, it does it primarily through licensed bottlers. So it has manufacturing plants all over Europe and Asia that produce their product. And so actually, the majority of Coca-Cola sales take place overseas, outside the United States. So clearly, it's a multinational. And of course, multinationals get assaulted from time to time by progressive and labor activists who accuse it of human rights and environmental abuses. We've seen that certainly with the Nike and sweatshop accusations in Southeast Asia and so forth. So obviously, companies, especially multinationals, are sensitive about their brand and work very hard to maintain corporate responsibility activities. And obviously, it's bad for business to engage in uh, illegal or unethical conduct because that boomerangs on them and, of course, harms their business image. And of course, we know companies spend fortunes trying to maintain their image. So even though Coca-Cola was founded in the late 1800s, she still spends an enormous amount of money on maintaining her brand. Everybody knows who Coca-Cola is. Well, because Coca-Cola continues telling us that they're there and what their products are. So certainly a measure of power in the activity of a multinational is its foreign direct investment. That is, how much is the multinational company, investing for starting, acquiring, or expanding an enterprise in another, nation. And so we see that certainly multinationals, depending on which approach they want to take or a series of approaches, whether or not they want to do set up their own production plant or whether they want to go through a licensed set of dealers. Lots of different ways that multinationals do business. And of course, that naturally brings into question, so how do you control multinational activity? Well, certainly when we talk about international codes, we're talking about voluntary aspirational statements. And hey, these are, these types of codes, international codes of conduct, are spreading and growing to try and create not just harmony, but obviously corporate social responsibility, good CSR. We know that if a company is publicly traded in the United States, that company under Sarbanes-Oxley has a legal requirement to develop a code of ethics and to train its employees on its code of ethics and to have annual reports on its code of ethics. So from an international perspective, the Organization for Economic Cooperation and Development, better known as the OECD, which is a very large international entity, has guidelines for multinational enterprises. What do those guidelines do, boys and girls? Well, they make recommendations as to how these multinational corporations should be conducting themselves. Even have general policies that are supplemented by even more guidelines trying to shape and obviously influence multinational conduct. Now, on the one hand, of course, these are international codes which are voluntary in nature. Nevertheless, remembering the brand, complaints by consumers and non-governmental agencies, NGOs that we've seen before, do encourage compliance. So in your text for today, for your chapter, you had a chance to review the company called Vedanta, an Indian company that was actually headquartered in Great Britain. They were accused of a violation of human rights of an indigenous people in India, where the company wanted to build a mine. So this non-governmental organization filed a formal complaint that the company was violating these international guidelines. The complaint was upheld, but of course, since it wasn't mandatory, Vedanta disagreed and said, hey, well, there's no means for being penalized, so we're not going to follow it. Are there repercussions? Yes. Partly as a result of the complaint, the government of India stepped in and stopped construction of the mine. So again, here we see a brand that is being tarnished as a result of the NGO and other complaints, and it has an impact. And so sustaining, maintaining, and promoting your brand is obviously an endeavor that every multinational corporation involves itself in. The United Nations Global Compact, if you will, is an international agreement that requires corporations to carry out a set of 10 principles that are based on established and emerging global norms. So look, you got over 6,500 corporations that are belonging to them. So with respect to United States multinational corporations, we have a special, actually, that dates all the way to 1789, called the Alien Tort Claims Act. Now, what does the Alien Tort Claims Act in the United States prohibit? It prohibits genocide, torture, and murder of ambassadors, of all things. But this dates all the way back to 1789. So what's its real application today? Obviously, activities that involve genocide or torture. So clearly those are activities multinationals do not want to be identified with. So there have been lawsuits, civil lawsuits in the past. There's the story of the Drummond Company that was sued by widows of murdered union leaders in Colombia, which I think is a good illustration of the case in point. But the jury in the United States did not find the company guilty of violating human rights. Nevertheless, what do you think the damage to the brand of the Drummond Company was by being dragged through this litigation, being accused of engaging in torture and the death of these union leaders? So while there hasn't been a lot of success in terms of Alien Tort Claims Act plaintiffs, nevertheless, going through the process and having the negative publicity certainly has a bad impact on your business and your international reputation. Now, your text goes to great length discussing the Union Carbide case. Now, while it's a 1984 case, nevertheless, it's a good illustration of a multinational corporation that got itself involved in a really serious international crisis. So Union Carbide, among other things, makes petrochemicals. And they had a plant that they established in Bhopal, India. And let me just go through the facts, because the facts are important here. There was a gas leak in this petrochemical plant that injured and killed over 1,000 Indians who lived and worked near the plant. So, to its credit, Union Carbide management stepped right up and said they had a moral responsibility for the plant and what occurred. Well, let's peel back, the facts here and look exactly what happened here. Because while everybody, of course, is upset over what occurred, clearly everybody wants to know, why did it occur and who was responsible for what? And the facts are important. So the plant was run by a subsidiary company, the Union Carbide India Limited Company, uh, which had considerable autonomy in the operation and management of the plant in Bhopal, India. Now, one criticism of Union Carbide's American leaders was that they underestimated the risks of introducing an inappropriate, complex, and dangerous industrial technology into the Indian setting. That's clearly a judgment issue, but that is a pretty general type of complaint that could be lodged against just about any company. Not a whole lot of specifics in that, and that obviously is a judgment issue, hard to equate into any numbers or clear yes and no types of decisions. So the question is naturally posed, can managers delegate authority but not responsibility for the operation of a plant? And I think that's what the Union Carbide CEO said, look, they accepted a moral responsibility for what occurred at the plant. So what actually occurred at the Union Carbide plant? So the subsidiary had managers who oversaw the plant operations. Now, these were all Indians. There were no Americans or non-Indians involved. Now, the managers certainly could have been, as the subsequent reports reveal, could have been more attentive to the risks posed by lower training standards, the operating economies, staffing cuts, deferred maintenance, and processing shortcuts that they were engaged in. Now, managers, certainly at the operational level of the subsidiary, bore some responsibility for this complacency. Of course, the question becomes, how much responsibility versus the parent company? Well, in 2010, an Indian court convicted 7 of the subsidiary managers of causing death by negligence, giving them 2-year sentences. Okay, so the subsidiary company found itself hammered by their own Indian courts. There was an allegation that one worker actually caused the explosion of the petrochemical plant, and that he acted as a saboteur. But there's some debate and some argument and disagreement, about whether or not that actually occurred. The Indian government posed its investigation that there was a water washing theory that involved sloppy work that contributed to the accident, that the workers were too low in the company hierarchy to even see the flawed management controls of its Indian supervisors. And of course, they may have been poorly trained to appreciate the safety risks in running this petrochemical plant, and that the workers had little influence over policy. Not unusual in third world countries, right? So even had emergency plans that didn't work in terms of getaway buses that are supposed to be evacuating neighborhoods. Just about everything went wrong in this perfect storm that could. Bhopal community officials bore some responsibility because they were lax in enforcing residential codes to prevent slum dwellers from settling near the plant. So when the plant was originally built, nobody lived around it. Well, of course, as the years went by, the community, like airports, grew up around Bhopal, the Bhopal plant, when in fact city officials should have, for safety reasons, kept these residences from being built, but they didn't enforce their own codes. So there's some liability there. State and federal governments, well, there's the Foreign Exchange Regulation Act of 1973 that India had, which prohibited American managers from running the plant. So the Bhopal plant could only be run by India managers. And wouldn't you know it, it's one of the poorest states in India. Yet, like even in the United States, local communities and states provided incentives for the plant's construction, and later encouraged, the building of other petrochemical production units that made the plant more dangerous when it formulated pesticides and shipped in ingredients. So petrochemical plants, as you might imagine, are dangerous, inherently dangerous activities. And at the time of the gas leak that obviously broke out and injured and killed people in the nearby area, in subsequent investigations disclosed insufficient staffing and inadequate equipment to inspect the industrial facilities. Clearly local problems. So the question is posed, should local safety standards as opposed to much higher U.S. safety standards have been imposed? Well, of course we know the way it works internationally is when a company operates in a foreign country, that company is required to adhere to that country's local law. And it may even also be required to adhere to U.S. law. So, and when there's conflict, obviously, local law on the scene is going to prevail for local operations. So that brings us to this discussion of corporate social responsibility and business ethics. So bringing it into play, we certainly would say, look, a company has the purpose of creating wealth, and that's a good thing, right? However, it can only ethically engage in wealth creation activities that in fact do not create harm, that in fact do protect and enhance societal assets. So ultimately, clearly Union Carbide parent corporation and its subsidiary didn't live up to this standard, because look what happened, right? So certainly responsibility starts, at the top, and the CEO at Union Carbide assumed moral responsibility. He said at the very beginning of the catastrophe, but clearly closer monitoring and higher safety standards were necessary for the plant in a less developed nation. But of course, that was hindered by the Indian federal law that prohibited foreign nationals like Americans from actually managing the plant, which obviously, creates an impediment. So up until this time, Union Carbide was always viewed, as a good company, adhering to, high standards of safety. And so it had a good safety record up to this point. So certainly, when we look at ethical principles involved, which ones do we want to apply? Aristotle's theory of ethical responsibility can be applied here, which says that a person, or in this case, of course, a corporation, is responsible for the rightness or wrongness of their actions. However, there are two factors, ignorance or incapacity, that excuse or diminish responsibility. So let's test those two factors to this case, ignorance and incapacity. Was Union Carbide, the parent, ignorant of conditions and risks at the Bhopal plant? Having delegated operation of the plant to its subsidiary and removed Americans from the facility to comply with Indian law, American managers knew little about its operations, right? They were following local law that, prohibited them from having American managers or from, managing the plant. So does this sound like purposeful ignorance to you? I'm not so sure it's purposeful ignorance, because it's being imposed by local law. So managers at the subsidiary must have or should have known the details. Should they have reported those to the parent company? Most certainly, yes. Was Union Carbide incapacitated in any way from acting or reducing the risk? Yes, the subsidiary didn't inform it about all the problems that it was suffering, And of course, because of the Indian federal law, was unable to have their own managers on scene in order to supervise the operations of the plant, let alone convey important information. So the Indian federal law could be seen as an external force that prevented the American company from taking more responsibility. It lacked the power, the legal power, to intervene. So that would make its ethical responsibility diminished, if not eliminated, right? So let's talk about the legal system. Oh, yeah, we want to talk about the legal system. How about lawsuits in India? Now, you remember there was, and we'll talk about that, there were lawsuits initially that were filed in the United States. Clearly, a case of this magnitude involving an American multinational and over 1,000 would-be plaintiffs. You had a lot of American attorneys who wanted to represent these plaintiffs and filed an action that was eventually consolidated in a federal district court in New York. Now, the federal district court said, look, after having reviewed the facts in this case, we're declining jurisdiction over this case because under the legal doctrine of forum non-convenience, this case ought to be tried in India. Why should this case be tried in India? Because the witnesses, the records, and evidence are in India, and Indian law is probably applicable. Travel costs and everything would be reduced and whatnot. Well, why do you think the American attorneys representing the Indian plaintiffs want to try the case in the United States? Clearly, the potential penalties, compensatory damages, are going to be much higher within the legal system of the United States than that of India. So the case ended up in Indian court, not U.S. court. Now, the Indian government sued only the parent corporation. It didn't sue the Indian subsidiary. Isn't that interesting? There wasn't any precedent, in international law for this. There were 5 Indian judges who came and went over the years of the case's litigation. By 1987, the Indian Supreme Court issued a ruling handed down by a judge on the day he retired that set a precedent beyond strict liability, creating a new theory of absolute liability under which the parent corporation would be held responsible for the gas leak no matter what happened. Wow, that's a pretty plenary type of legal holding, right? So one judge held that the Union Carbide, the parent, had to pay $250 million for the gas leak to the injured victims, but that, wouldn't you know it, got overturned by a higher Indian court. So clearly the sabotage theory that I talked about earlier was something that the Union Carbide tried to increase knowledge and notice of. There was ultimately a $470 million settlement between the parent company and the victims of Bhopal that capped liability and brought the litigation to conclusion. Now, while there was originally a settlement accepted in U.S. court by U.S. attorneys for U.S. victims, ultimately, U.S. attorneys, thought that they wanted to get more money, and the Supreme Court of India finally settled the entire matter to everybody's satisfaction with a $470 million, settlement. That obviously was a lot of money to victims whose average income was less than $300 a person per year. So, questions arise. Ethical questions. Was the company sufficiently punished? Well, if you go back on those original criteria that we looked at, was the company, was it ignorant of the facts on the ground of what was happening in Bhopal? Did it have the capacity? the legal capacity to properly supervise and administer the plant. And so those are the issues in play. Lots of arguments about the monetary piece, but under the circumstances, ultimately, after years of litigation, the $470 million is what finally brought the litigation to conclusion. Now, of course, over the period of years, while this case dragged on, it was in the international focus. Certainly, it was a cause célèbre in the United States, not to mention India. And so certainly the parent company, Union Carbide, suffered a great deal. Its brand, if you will, wasn't just diminished, it was, crushed. And so while other types of civil tort suits might have brought or did bring a great deal more money, nevertheless, given the international scope and complexity and liability of subsidiary companies, that make this a difficult case, certainly for Union Carbide, which ultimately ended up in Union Carbide's merging with Dow Chemical. Did Union Carbide handle this particular crisis very well? Well, given the handicaps that it had in terms of ignorance of what's going on the ground and legal prohibition from actually managing the plant or even having any Americans from the parent company involved in its management or inspection, the company was certainly handicapped from the beginning. And so, these are questions that the company should have certainly addressed going in to India to do business. And seeing these types of problems, perhaps they should have made a decision not to do business under these circumstances. And that perhaps is the judgmental weakness or failure of Union Carbide at the parent company level, in that given these handicaps and restrictions by the Indian government, the problem of enforcement of local codes and safety issues, that this wasn't in the long term a good business proposition in terms of ethics and safety for Union Carbide. But greed is a difficult thing sometimes to deal with at an international level. But again, one has to be prepared for the unexpected, and especially when you're dealing with a legal system that is highly fluid and doesn't necessarily follow international law. Those should be all the warning signals that lead you to consider whether or not this is a good, appropriate business investment, especially in terms of ethical responsibilities. So those are the brief issues I wanted to bring to your attention today. I recommend that you continue to work ahead so that you don't become inundated with projects, papers, and tests and whatnot as we march toward the second half of our semester. As always, if you have any needs, questions, issues, I invite you to tickle my chain, rattle my cage, send me an email. I'm here for you. Okay? All right. Stay well. Hua.